This is Bloomberg Law with June Grasso from Bloomberg Radio.
Luigi Mangione railed about double jeopardy during an unusual courtroom outburst after a judge set his state trial for June 8th, leapfrogging an October trial date set by a judge for his federal trial. Mangione's defense team objected to the June date, saying they won't be ready in time and that their client faces the threat of double jeopardy. As court officers led him from the courtroom, Mangione shouted, "It's the same trial twice. 1 + 1 = 2. This is double jeopardy by any common sense definition." Mangione is charged with killing United Healthcare CEO Brian Thompson on a Manhattan sidewalk in December of 2024. Both the state and the federal government are trying him for Thompson's killing. His lawyers have pushed for the federal trial to go first, which could bar the state trial from happening because of New York's double jeopardy protections. At Friday's hearing, Mangione's defense attorney, Karen Friedman-Agnifilo, repeatedly said the June trial date places an unfair burden on Mangione's team to prepare for the federal and state trials at the same time. Quote, "Mr. Mangione is being put in an untenable situation because of this tug of war between two different prosecution offices." Judge Gregory Caro's response was, "Be ready on June 8th. That's it." Joining me is Bloomberg legal reporter David Voreacos. So, David, basically, Manhattan prosecutors are fighting with federal prosecutors over who gets to try Mangione first.
That's correct. The judge in the federal case ruled that Mangione could not be tried on a murder count that could lead to the death penalty, which is what the Trump administration was looking for. Now, this would be the death penalty if the jury found him guilty and then the jury then decided that he should be put to death. She took that option off the table for legal reasons, saying that essentially the underlying charge or the related charge of stalking with the intent to kill was not the appropriate one to use with this murder count. So she dismissed the murder count and a firearms offense, but left the stalking charges, and there are two stalking charges for Mangione, who still could face life in prison if he's convicted of those. The judge set a September 8th date to begin jury selection in that case, unless the prosecutors appeal her ruling, and it's not clear that they will. Meanwhile, just last week, the judge in the state case, who had previously thrown out a first-degree murder charge and left in place a second-degree murder charge, set a June 8th trial date for Mangione, and he said that he would move that to September 8th if the federal prosecutors appeal.
I thought long ago the feds had said that they would let the state go first. And Judge Caro noted, quote, "It appears the federal government has reneged on its agreement to let the state, which has done most of the work in this case, go first."
There has been discussion of an agreement. It's just a little unclear how that agreement was supposed to be enforced. And the judge in the federal case went ahead and set a September 8th trial date because the judge in the state case had not acted. And there was a very intense hearing on Friday, after which Mangione was shackled and being led out of court, and he turned and shouted to the gallery, "It's the same trial twice. 1 + 1 = 2. Double jeopardy by any common sense definition." Now, this is not a normal turn of events where the defendant would make such a pronouncement to the gallery. What he's referring to is that his lawyers have argued consistently that by charging him for the same act, the allegation is that he murdered United Health Group executive Brian Thompson, by charging him twice for the same act, that amounts to double jeopardy, which is barred in the U.S. Constitution and under New York state law. So there's been a lot of jockeying between federal and state prosecutors to see who was going to go first.
Isn't it accepted that it's two different sovereigns and you can try a person in state court and federal court?
I think it's unclear how the facts of this case will play out and how the law will play out in this case. There's clearly competition, and you could imagine that, say, the judges or the prosecutors would get together and resolve this, but this seems to be proceeding not in an amicable fashion.
If you look at it, without all the publicity, it seems to be a classic state case. It's a killing on the streets of Manhattan.
It is more traditionally a state prosecution, and the judge said that. The state court judge said that on Friday, that this is more traditionally something that would go on. And that's something that the prosecutors for Manhattan District Attorney Alvin Bragg have been arguing all along, that they investigated this case with the New York Police Department, and they collected all the evidence and put out the bulletins that led to Mangione's arrest in Altoona, Pennsylvania, and that the Justice Department and the federal government only got involved essentially after the New York Police Department and the Manhattan DA had done the bulk of their investigation. And if you recall, the Attorney General Pam Bondi said that the Justice Department was going to seek the death penalty before the Southern District of New York prosecutors had secured a federal indictment.
And Bondi was criticized for making that decision before she even knew the facts of the case. Why does each side want to go first? Is there a concern, perhaps, that the argument of double jeopardy will come up after the verdict in a first trial? And also, perhaps, that a second trial is less of a surprise for the defense, so they may have an advantage?
It's not entirely clear why it's so important to each side to go first. I mean, I assume for publicity value and, the evidence is fresher, the witnesses are fresher. As you suggest, the defense might have a better shot the second time around. But say if Mangione is convicted and faces a life sentence, it's not entirely clear that he would want to go through that a second time. You could imagine that might give leverage for a plea deal, averting a second trial.
Key evidence in the case was found in Mangione's backpack that was searched at that McDonald's in Pennsylvania, where he was arrested. And the defense has been fighting to keep that evidence out of the trial, arguing it was an illegal search. But the state judge, Judge Caro, is not going to issue a ruling on whether that critical evidence is in or out until May 18th, when he set the trial date for June 8th.
The state court judge is going to rule in May, which is almost 6 months after he had a 7-day hearing on the matter, whereas the federal judge had a single hearing with one witness on it and ruled promptly that the evidence collected in Luigi Mangione's backpack in a McDonald's in Altoona, Pennsylvania, was admissible in the federal trial. So she ruled against the defense request to throw out that evidence, which, if it's admitted, is, according to the New York authorities, very damning. It includes what they say was the gun that was used to murder Thompson. It includes a silencer, a gun magazine, and a diary that authorities say included a number of writings suggesting that Mangione was planning to murder Brian Thompson.
This sort of illustrates the differences between practicing in state court and federal court. First Brands founder Patrick James and his brother Edward pleaded not guilty to fraud charges stemming from the multi-billion-dollar collapse of their auto parts supply business. Prosecutors say that as a result of the defrauding of the company's lenders and financing partners, hundreds of millions of dollars flowed into the personal accounts of Patrick James. Federal prosecutors allege the two former First Brands executives used fake and inflated invoices to persuade lenders to provide billions of dollars in financing to the company. Jay Clayton, the U.S. Attorney for the Southern District of New York, said the James brothers obtained billions for First Brands and millions for themselves by presenting their lenders with the impression of a successful, growing international business. He said it was a business run through fraud, fake documents, and false financials. The indictment follows separate civil lawsuits brought against the brothers by First Brands bankruptcy advisors. The company filed for Chapter 11 bankruptcy in September of last year with just $12 million in its corporate accounts and more than $9 billion in liabilities. I've been talking to Bloomberg legal reporter David Voreacos. Tell us about the charges, David.
Patrick James was the founder of First Brands, which is a big auto parts supply business that filed for bankruptcy last year. And the allegations are that he and his brother, who was a top executive, engaged in a massive fraud scheme regarding the financing of billions of dollars to the company. And they were indicted on charges including wire fraud, bank fraud, conspiracy to commit wire fraud, and conspiracy to commit money laundering.
And explain how prosecutors say they committed these frauds.
They are accused of essentially creating false invoices, using fake and inflated invoices to persuade lenders to give them financing that they needed to keep their business going. And, there's allegations of round-trip financing, and a lot of this has already been aired and litigated in bankruptcy court. The prosecutors in the Southern District of New York say that it amounted to a criminal scheme. Of course, the brothers have pleaded not guilty and, through their lawyers, deny wrongdoing. The prosecutors have also secured the guilty plea and cooperation of a big executive, Peter Brumbergs, who pleaded guilty under seal and will be testifying at a trial that's scheduled to begin on July 13th.
And prosecutors say that they have recordings?
They have consensual recordings. They said that in a hearing, but the nature of those recordings and who's on them is unclear at the moment.
So most of this was litigated or brought up in bankruptcy court. What did they find in bankruptcy court?
There was a great deal of money that essentially went missing, according to creditors. There's one lawsuit that accuses Patrick James of misappropriating more than $700 million between 2018 and last September. And they say that helped James and his family live their lavish lifestyle. James, of course, denies that. And essentially their defense is that they were the victims of self-interested, sophisticated institutions that placed what they said were patently absurd interest rates and fees on their borrowings.
So they are accusing the lenders of engaging in predatory practices. Are they also claiming that the tariffs played a part in this?
They do blame the tariffs a bit too. That was a factor that changed the business environment that helped lead to their bankruptcy.
How much money do they have now?
It's unclear. They have many millions of dollars now. Patrick James is free on a $50 million bond, and Edward James is free on a $25 million bond. And they had to put up a portion of that in cash and also post properties to secure their bond. So this is a big part of the bankruptcy litigation, is just how much money do they have and how much were they paid through the companies. It's a private company that Patrick James owns. And so the accounting is not quite as transparent as if it had been a public company.
And the penalties are pretty stiff here if they're convicted.
Yes, I believe it's life in prison for Patrick James. And, as with all of these financial frauds that involve wire fraud and bank fraud, it's potentially dozens of years in prison. Typically, white-collar executives receive far less than that, but, they're looking at very serious time if they're convicted in this case.
So trial is set for July 13th. I imagine that's going to be a very complicated trial with lots of documents. Do you know how long the trial is expected to take?
Well, it's a complex financial fraud, and I don't think the prosecutors have yet said how long they need to present their case, but I would imagine if it's anything like similar cases, it would be several weeks. And so far, it appears that the most powerful evidence they have would be testimony from Peter Brumberg's, the cooperating First Brands executive who pleaded guilty.
Thanks so much, David. That's Bloomberg legal reporter David Voreacos. In other legal news today, a landmark trial. For the first time, Uber has been found liable for not preventing an alleged sexual assault of a passenger. The rideshare giant was hit with an $8.5 million verdict in a jury trial in Arizona where a 19-year-old woman said she was raped by her driver. The company said it plans to appeal. The jury found that Uber was liable because the driver was acting as an apparent agent of the company. But the jury said Uber didn't act negligently or design a defective product. But the verdict does raise the risk of a costly settlement to resolve the more than 3,000 similar civil lawsuits from passengers filed around the country. Uber did prevail in a similar case last year in California State Court. Joining me is Dana Whitfield, a partner at Spar Bernstein. Uber for years has been fighting these sexual assault claims by arguing that the company can't be blamed, that the drivers are independent contractors. Can you tell us a little bit about that?
Sure. Well, that's always been their go-to response, and it's true. They are independent contractors. However, despite them being an independent contractor, they still are only able to access passengers through the software that was created by Uber. So since there is a level of respondeat superior is the actual legal term, where the fact that they both gain something, they become an agent of Uber. These drivers do. Uber is the one that retains and collects the fare. They pay these drivers based on the software that's used and the access. So despite there being an independent contractor situation, they also are able to say that you're an agent of Uber, so therefore Uber has a responsibility to their passengers who they promote this software to, that they're going to be safe and they're going to implement safety measures to prevent the drivers from assaulting passengers.
So tell us about how the jury came down here on the agency and on negligence.
Well, the jurors clearly found that Uber not only failed to implement the safety measures, but they also failed to properly screen these drivers. So you had mentioned earlier that there have been, numerous complaints, and they've known this for years. It actually goes back to these complaints coming as early as 2014. Also, in December of 2019, Uber had released a safety report that showed that passengers had filed more than 3,000 complaints of sexual assault back then. So they've had the knowledge for many years that they could have done more. They could have, as I mentioned, properly screened them, or at the bare minimum, they could have advised and alerted passengers of the risks of sexual assault by their drivers, because a passenger is not going to know that there's an independent contractor situation, that these drivers are using their own vehicles, sometimes their own insurance as well. So therefore, you're putting your faith into a billion-dollar company such as Uber, but really your safety, you're at risk because there's just a driver who may only have a $100,000 policy limit, and you don't know where they previously worked, or if they are just maybe even out of prison. You have no idea who is driving you. You only know that you're trusting Uber because you downloaded the app.
But the jury didn't find that Uber was negligent.
They found that there was clearly an issue with regard to the sexual assault. So they were liable because of the agency. That's where they found that there has to be some risk. So the award of, I believe it was $8.5 million to this young lady, was based on the fact that while the criminal action was that of the driver, it was Uber who failed to implement these safety precautions.
Is Uber sort of taking comfort in the fact that it wasn't found guilty of negligence despite everything that you just mentioned?
It's going to be what they're going to hang their hat on, but I think it's going to set a precedent that based on the fact that there are thousands of other cases, that this is going to be something that other states will actually hold on to. And there are women who are finding that I've been assaulted by an Uber driver, and despite there being this relationship where they're an independent contractor, Uber had knowledge and could have done something to protect me. So I think they're going to have an issue with regard to other states looking to make sure that this decision now will set a precedent for other states as well in federal court.
Yeah, so federal court. So explain how this is a bellwether trial.
It's a bellwether trial because of the magnitude, because there's so many cases. And they've done this also with the hair relaxer cases where there are, instead of making it a class action suit, they put them all under one umbrella so that there is one measure to kind of corral everyone into one case. So that's why they use the bellwether trial. In
the California state trial, that ended with a different verdict. The jury found in that case that Uber wasn't liable. How do you account for the differences? It depends on the jurors, but I think that now we have the contradiction. And it also could have been that the case in California was many years before. We're still dealing with the fact that what have they done to change? There's a level of notice now that comes into play, I believe, with the Arizona decision, is that if nothing has changed and you're aware that there have been thousands of complaints of sexual assault and you're still advertising and you're still promoting that you are safe, when really that's not true. So that was the main issue, is that I think that they are looking into, are you looking at just the profits or are you looking at the safety of your passengers? And if there's a priority with regard to the profits, that's an issue. Where does it fit in that Uber has, rolled out some safety measures? You can share your ride location with friends. There's an option if you want a female driver. Where does that fit into these cases? I think that that's a start, of course, but I think with regard to the negligent supervision, that's something that no matter if you've shared your ride and you've requested a female driver, what if there's nobody else that's available? You still need to get that ride. You still need to get home. And there has to be a level of screening that has to take place before you're even putting someone in the position to actually be in a car with someone where you could be victimized. So that's where I think the Arizona jurors found there to be something that was lacking, that it wasn't enough, that there should be something done with regard to screening before they're even allowed to have access to the app to be able to reach these passengers. So what do you think Uber's chances on appeal are? I mean, there's always, a 50-50 chance. You really can't tell. I mean, because there's been conflicting decisions, I think that there's a chance, but it really just a matter if there's going to be a consensus with regard to, could there have been something that was a misrepresentation of the law? And I don't believe that in this case that there was. So do you think that we'll start to see settlements in some of these cases? I think we're already seeing settlements in some of these cases, which is why so many have not made it to the federal court or even to state court. But I think that this decision will now put Uber on notice that if you're not going to change the approach and you're not going to change the advertising and the safety measures, that we're going to be seeing a few more settlements until there's a decision or an appeal that states otherwise. Thanks so much for joining me today. That's Dana Whitfield, managing partner of the Personal Injury Department at Spar Bernstein. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.